All rise. The Court of Appeals Division 1 is now in session.
Please be seated. Sorry. Thank you. We're on the record in CV210713, Newbanks versus Newbanks et al. We are live streaming and recording these proceedings, so when you get up to the podium, if you'd announce your own name as well as your client's name, we thank you for that. You each have 20 minutes to argue. The time is here on the clock, so you're responsible for keeping your own time. Appellant can reserve time if you wish to. Please keep in mind that we have read the briefing, studied the record, and did discuss this case in our conference prior to oral arguments. And with that, you may proceed.
Good morning, Your Honors. May it please the Court, my name is Jerome Elwell, and with my associate Yvonne Tyndall, we represent Nancy Newbanks, the appellant. Your Honor, this case involves the application of an in terrorem clause at the trial court level. The basic facts that you are aware of, so I will breeze through them, are that in 1985, Hal and Mary created their own trust. Upon the first of those to die, their assets split into two trusts, Mary's trust and Hal's trust. They called them the decedent's trust and the survivor's trust. The assets that went into Mary's trust were her sole and separate assets and one half of the community property. Same with Hal. Upon Mary's death, her trust became irrevocable, which is a very important point for today's discussion. Following Mary's death, Hal decided to...
Upon Mary's death, though, her will did not put the personal property. It put all the personal assets, I believe, or her personal effects. She gave that to Hal, correct?
She gave that to Hal, correct.
So her trust simply included her share of the community property.
Correct, Your Honor.
Okay.
So following Mary's death, Hal decided to make some changes to his estate plan. He did a First Amendment that changed Nancy's distribution from the survivor's trust so that she would receive Mary's jewelry and forgiveness of a $50,000 debt, a loan. And the appellees acknowledge it would also provide Mary with sufficient cash to equalize a one-third distribution of the assets of the entire trust.
And I believe you said the survivors, it's from the decedent's trust.
From the decedent's trust. Well, from the entire trust, Your Honor. What the appellees have discussed is, in their briefs, have acknowledged that if the First Amendment is applicable, then Mary would get a relief of a $50,000 debt, she would get the jewelry, and then she would get sufficient other assets or cash to equalize a one-third distribution from the entirety of the trust. When I say the entirety of the trust, I mean the survivor and decedent's trust together.
And it might make sense to use mother, father, daughter, because you just said Mary would get. That's mother.
I apologize, Your Honor. So from Mary and Hal's total trust, Nancy would receive one-third.
Okay.
Okay. Now the second...
let me just break this down, because I think it's important to understand the steps. My understanding is there's a family trust. When mother died, her community property went into her trust. And I'm going to call it a subtrust. And that was irrevocable. So that held her share of the community property.
Correct. Mary's
irrevocably
subtrust
to be
was
divided
irrevocable
between the three children.
Yes, Your Honor.
Father's trust held everything that he had, his subtrust, unless he changed that in a will or a further amendment of his subtrust.
Unless
Correct?
he validly changed his trust. Correct.
And he could validly change it any way he wanted. But he could not change the mother's subtrust.
Spot on, Judge. Exactly.
Okay.
Is that the end of that question? Okay.
Because I think we wandered a bit from what was happening. And I think it's still, these two subtrusts are part of the family trust, right?
Correct.
Because you were calling it one trust, and that was the problem. I've got two subtrusts under one family trust.
Yes, Your Honor.
But once husband dies, it's just the family trust. Everything's in there. But
Well, it's all,
but if as part of his amendment, he said you will get an amount sufficient to have the overall amount that you get be 1/3 of everything. That in theory is modifying, I mean, it's not really modifying. If he had enough, let's say he didn't have very many assets, if you're equalizing it, you would be reducing something that daughter would otherwise be entitled to get under mother's share of the trust. If there's enough money, then father is just saying, you're going to get enough to make sure there's an equal distribution.
All things being equal, that is correct, Your Honor. In my mind, I look at it as a diamond, almost. You start out with the family trust at the top. When first to die dies, you divide the assets into two. Now, what Mary, mom, did with her assets was she gave them to the three children equally, divided them into equally. What father did before any amendments was the same, give them to the three children.
He didn't do it, though. He said, I'm going to put it in mother's trust to give out under her terms.
Correct.
So it's not a diamond, it's a triangle standing on end, because I think that's an
Would that be a
important
trapezoid?
distinction.
So he did, you're right, Your Honor. His original trust and the First Amendment both took the residuary of his trust and poured it into the survivor's trust, mom's trust.
So the family trust and the First Amendment are consistent, and true that the will is also did the same thing.
Correct.
So it all went over to mother's share, and then the distribution went based on that irrevocable provision.
Correct.
Okay.
Now, after Hal died, I'm sorry, let's talk about what the Second Amendment did then. The Second Amendment, which was drafted by father's son and executed 1 month before father died, under what the trial court indicated were troublesome circumstances, disinherited Nancy completely.
Couldn't disinherit her from what's in mother's trust.
It could not,
Right.
but it attempted to disinherit her from everything that was in the survivor's trust or dad's trust, Hal's trust, subtrust.
And can I ask you, was there a ruling from the court on the validity of the Second Amendment?
Well, we think there was, Judge. So what the trial court, now my opponent will tell you that there was no ruling by the trial court on the validity of the Second Amendment.
But the court chose not to enforce it.
What the trial court did, was they said there are 3 documents which are the controlling documents in this case. There's the will, the First Amendment, and the irrevocable subtrust. Those 3 documents are the enforceable documents.
That includes the First Amendment.
That included the First Amendment.
I guess our question, though, is how are we to treat the Second Amendment? Is that a judgment that the Second Amendment is not something to be considered? If it gets sent back, is that something that's at play again? How do we frame what the Superior Court said about the Second Amendment in terms of the finality of that decision? From your perspective.
It can't be enforceable, Your Honor, because the trial court said these are the 3 documents that are the controlling instruments. If it wanted the Second Amendment to be a controlling instrument, it would have said so. Further, if you read the trial court's order, they required my opponents to draft a judgment. Read that judgment carefully and show me anywhere where it even talks about the Second Amendment. Even they recognize that the Second Amendment is invalid. So,
Because you don't challenge that ruling and they didn't cross appeal, is that final no matter what we do? Or if we reverse and remand, does that put it back in play?
That was my question.
from my perspective, the Second Amendment is invalid, and that ruling was never appealed by my opponents. Therefore, it is a final ruling by the trial court. It's not in the order. The Second Amendment isn't in the order or the judgment anywhere as a controlling document. And I believe that renders that document invalid and not enforceable and not in play, regardless of what this court does.
Is there anything about what the court did that would suggest that the court was somehow trying to split the baby and not wanting to make a ruling on the Second Amendment?
The first part of your question, yes. The second part of your question, I don't think so. The first part of your question is, was the judge trying to split the baby? I think so. But I think what the trial court did is overstep the bounds, the scope of the interim clause, and then tried to make up a mechanism whereby he could kind of do what he thought was Hal's intent based on what opposing counsel would tell you the Second Amendment wanted to disinherit his daughter.
Can I ask you about the interim clause?
Yes.
In your view, they suggest several challenges that they suggest are all inconsistent with the interim clause. Are there any that you're conceding are inconsistent with that clause, or that are that would result in her being disinherited?
None that would result in her being disinherited. I think the interim clause requires a two-step analysis. One, is it implicated? And two, is it enforced? Whether or not the interim clause is implicated is based on the interim clause and the language therein. This interim clause was very limited. Hal, the husband, father, indicated that he wanted nobody to challenge the enforceability, the validity of his interim clause, or his trust and his will. The trial court said, even in their order, and even in the judgment drafted by opposing counsel, that she challenged the process. And she did challenge the process. There's no doubt about that. She challenged whether or not the trustees should remain as trustees. That doesn't challenge whether or not the document's valid. It challenges whether the trustees should be removed. She challenged whether or not filing a document or filing a challenge would violate the interim clause. That doesn't invalidate or attempt to invalidate the trust. Instead, it simply says, if I do this, would I violate the interim clause? And she withdrew all of those allegations. The interim clause also
Even assuming they're not withdrawn, are there any that would implicate the interim clause?
One.
Which one?
It's the challenge to the validity of the First and Second Amendment. She did challenge the validity of the First and Second Amendments, and she was right. She was right.
On the Second Amendment?
On the Second Amendment. She had probable cause to believe that she would be successful in challenging the Second Amendment. And from our perspective, she was correct in that challenge, in that the Second Amendment was not enforced by the trial court.
Wasn't she also right on the First Amendment in that at least in part, the provisions trying to limit her ability to take under the decedent trust were also invalid?
Thank you, Your Honor. Yes, we believe for two reasons that she was correct on the probable cause to challenge the First Amendment. The first being what you just said. It attempted to remove her right to take under the survivor's decedent's trust. However, there were factors that she was entitled to rely on. She asked for information about the trust after Hal died, and she was told, you're no longer a beneficiary, you can't have it. That was wrong. She was a beneficiary under the family trust. She was told that she couldn't have that information. Then she asked for an accounting. She was told she couldn't have an accounting. She relied on independent counsel, which under the Wolf decision, that's one of the factors this court should consider as to whether or not probable cause was based on a reasonable belief that you would be successful at the time of the challenge, at the time of filing. So there's a laundry list of things that she relied on, and we believe, and I would ask the court's indulgence for just a moment while I find that laundry list. She was precluded from having information concerning the trust after Hal died. She was told wrongly by the lawyer representing the trustees that she was not a beneficiary of the trust. The information was concealed from Nancy following her father's death. She was not told about the Second Amendment until February of 2019, and then she was denied information about the trust administration. The Second Amendment was executed 1 month before Hal died. The Second Amendment was created by one of the children of Hal. There was a confidential relationship between Hal and Scott, the person who created that Second Amendment. Scott created, from my client's perspective, an atmosphere of isolation of Hal. And the fact that and Nancy was represented by independent counsel. Those factors we don't see the court considering, the trial court, considering any of those factors before it made a determination that Nancy purportedly violated the interim clause.
And to be clear, she only has to have probable cause. She doesn't have to win. She just needs to have a factual basis.
Pursuant to the case law, Your Honor, you're correct. She needs to have a reasonable belief that she would be successful, and her belief needs to be both objectively and subjectively reasonable.
And wouldn't it be isn't it a different claim to say, if you're suggesting that father was not competent when this was drafted, is that a challenge to the will itself?
That's not in the record, Your Honor. There was no challenge to father.
Okay, I'm suggesting that would have been, if you're challenging the Second Amendment and all the circumstances, you're suggesting that it wasn't, there was something untoward about how that was, that it may not have been his wishes, that it was something that was...
Correct.
So I think I'm making a point that's helpful to your side, that it's...
And thank you.
That would not be necessarily challenging the document as opposed to challenging whether someone was competent, to the extent that that was what was being argued, but maybe that's not what you were...
So if I were to go to the trial court in an unrelated case and say the Second Amendment to the trust is invalid because father lacked capacity, I believe that that is a challenge to the validity of the document.
It's not a procedural challenge. It's not how the process is working. It's how the document was
It's whether the
procured. And in this
document-
case, was it more coercion that the argument was as opposed to lack of capacity?
Correct. We believe that there was a characteristics of isolation, the fact that there was a wedge driven between father and daughter, the time frame, 1 month after, from 1985 all the way through to the date of his
Well,
death.
and the court agreed, and chose not to enforce that. So there was clearly a reasonable basis for making whatever claim she was asserting as to the Second Amendment.
We believe so, yes, Your Honor.
So now I just want to clarify something very quickly so you have your time. But do we need to reach the forfeiture clause issue or the interim clause issue? And I ask that because it seems to me if we follow the plain language through, doesn't it go, no matter what happens, everything goes into the decedent's trust under all of the documents except the Second Amendment? So even if the interim clause applied, I think you make this argument, that it doesn't preclude daughter from still taking 1/3 of everything in the decedent's trust, and that includes everything from father.
Correct, Your Honor. We believe that the interim clause cannot be enforced. We believe that the trial court expanded the scope of the interim clause. But even if you enforce the interim clause, you cannot change the irrevocability of mom's trust.
And that's my point. The interim clause becomes a red herring. You could concede her violation, and she would still be, under the express terms of the documents, entitled to the same thing.
100%.
Okay.
Thank you, Your Honor. If I could, I'd reserve the rest of my time. I think I've got about 2 minutes.
Thank you.
Good morning. It's a pleasure to be here with you.
Good morning.
The concern that we have today is looking at what Hal intended and what Mary intended. And
Is that ever an inquiry when there are documents that specify what happens with assets? Do we look beyond the document?
you are interpreting the documents.
Is
You
there
want to
some-
know what they were thinking and what they were trying to do.
But if they're ambiguous, I mean, if they read in a way that's not ambiguous, why would we interject ourselves further into what intent was if the words are plain?
And that's very true.
And what are you saying is ambiguous in?
Well, there's two things here. The trial judge validated the First Amendment and the will with the interim clause. And then there's the Second Amendment, which, just to be clear,
What does that have to do with intent, though? So that has nothing to do with intent. That's just, you're disinherited if you if you wrongfully challenge the provisions of the will. So, but I'm still not getting anything about intent of either of the testators.
All right. October 2014, Hal, the testator, goes into the hospital. During the time he's in the hospital, there is a theft, which the court found, by Nancy, in which he has taken the majority of the jewelry that belonged to Hal. That goes to the intent. What was Hal trying to do with the First Amendment? What was he trying to do with his will? Why did he have an interim?
But if he writes something if the document is clear what is to be done with that property, why do we care about his intent?
You don't, but it's not clear.
Why is it not clear? It says everything, and one, do you agree that the provisions that he said what would happen with the decedent trust? It seems to me in your answering brief you do, that the provisions regarding her only getting the jewelry, that the jewelry was worth $300,000 and the loan, that those provisions are not enforceable because the decedent's trust at that point was irrevocable.
The issue about him trying to substitute the jewelry, which totally belonged to him, was totally within his power, for the decedent's portion of the trust, mother's portion of the trust, I've written the brief in the sense that he didn't have power to make that decision, because what if he was wrong about the $300,000 that he put as a value on the jewelry?
Well, in fact, the Superior Court said he couldn't figure that out. So I think it was never established. So we X'd that out. That's all we can do with it. That language is gone. It's not unambiguous. It was the decedent's trust, not his. Now, he could have said from the survivor's trust. He could have done it differently, but he didn't. So then, the only other provision that applies is everything goes into the decedent's trust. Where's the ambiguity there?
Hal has an intention, and that intention is that he wants to handle the disinheritance in an interim clause his way. And you are preventing him from the opportunity of having his will executed.
The forfeiture clause only comes into place if there's a challenge. So that can't be an intent to disinherit somebody unless there's a violation. So there was no demonstration of intent in an interim clause.
If he keeps the jewelry, which belongs to him, and he divides his estate between his children 3 ways, and there's no interim clause, you would get a fair result. If you put everything in the decedent's trust...
Which is what he said to do.
He didn't... If you attribute that belief or intent to him, you'll end up with Nancy getting more than anybody else, which was obviously not his intent.
Couldn't he have done that in his will? I mean, the fact that he's trying to equalize the decedent's trust, which he had no right to change because it was irrevocable, he can't equalize anything in that because that's been set in stone since she died. The distribution that's going to come from that trust, no one can touch. And the idea that he decides to fund that trust with his survivor trust was a decision to put all of his assets in a place where he was no longer going to have any control about the distribution because that distribution was set and irrevocable when she died. So he may have had an intent, but it may have been a mistaken intent because I think he could have done what you said and divided the jewelry 3 ways in his will or done something different in that document. But once he decides that his will is going to fund his survivor trust, which is then going to fund the decedent trust, he has no capability of changing the distribution from that decedent trust. Is there something wrong in what I just said?
You would be completely taking away his power to control his survivor trust.
He had all the power to do it. He didn't maybe use it right because he could have dealt with all of his property in his will.
Did he place some condition on the amount that went into the decedent's trust, the family trust? Say, I will only put in the amount necessary to equalize? It seems like the documents are pretty straightforward, whether they reflect his intent or not. I'm not finding the ambiguity that you're suggesting.
How do you invalidate the interim clause? By simply, aren't you simply ignoring it? I'm not supposed to be asking.
Let me go back. Could I address the in terrorem clause? What are you suggesting was violated? I see a laundry list of things, including you said she sued the lawyers who were representing Sons, and that somehow violates the in terrorem clause?
I'm curious if you have somebody who comes in and files 26 claims, which I mentioned in the brief, and they're false claims. Let
me start with if you haven't been given an accounting that you're entitled to, what do you expect the person to do? They're represented by counsel, nevertheless, they're not being given an accounting. Don't they have to file a lawsuit at that point?
There's a difference. Well, if that were true,
Are you saying she was?
a basis.
Are you saying she was provided an accounting?
Yes. Look at the statute.
When was she provided the
In
accounting?
March she filed the petition asking for the accounting, I think in August, and she was provided all the documentation in March for the inventory of assets that's described in the statute. And people confuse an accounting, which is, there's a forensic accountant, you hire the expert, he goes through, he crunches all the numbers. You don't want to confuse that with the statutory duty to provide the amount of assets, which was done in March.
When was she told that she was not a beneficiary under either trust?
That was in the, let's see, how dies in it's April 2019, I believe.
She was told that she was not a beneficiary under either trust, the family trust or under house trust.
They're sending letters back and forth.
Okay.
She says, you're not a beneficiary. That's what.
And you now acknowledge that that's wrong. She was a beneficiary under the family trust.
The judge determined that she was a beneficiary.
And you agree that that was correct?
Yes.
So she should have been given any information that she requested having to do with that trust, and she was not given that.
Okay.
So why is her filing a lawsuit asking for what she's entitled to a violation of the in terrorem clause?
You can violate 26 times, but as long as you have one, that's okay, then you're all okay.
And if you're just challenging the administration of the trust?
No. If you look at the validity issue, you're talking about the validity of the will and the trust. You have this, okay, you're a beneficiary, says a trial court judge. But what about the fact?
Well, wait a second. I just want to start. It took till the trial court judge said it for your clients to acknowledge she was in fact a beneficiary? Because then I don't see where your claim even can lie for in terrorem, because you're saying, we weren't going to agree to that till we got this judgment. You're not saying you agree. You're just saying that the court ruled that way. Did you ever acknowledge to her earlier in the litigation that she was in fact a beneficiary?
Sure.
When?
We did the calculations to say if you have a decedent's trust and that has Mary's funds in it,
Yeah.
and our entire argument has been to exclude Howell's funds that he didn't want to put in the decedent's trust from this decedent's trust that Mary was, the portion that was irrevocable was Mary's ownership that couldn't be changed. That's what was irrevocable.
But you also wanted to take from that stuff that was in that First Amendment. In fact, that's what the court ultimately did, the jewelry, the loan. You wanted to charge that against her instead of just giving her her share, right? That's never been your position, that she could have even the 1/3 that was in Mother's Trust.
Absolutely not, because she violated the in terrorem clause.
But you're right, she had to sue your clients to get them to even acknowledge she was in fact a beneficiary.
So she comes in with her lawsuit, and what does she do? She says, I'm not just going to ask to be a beneficiary. I'm not just going to ask to get thousands and thousands of pages of documentation, which she did. She's saying, I want to get rid of you guys.
Okay, tell me which
problem.
petition and which claim, because I don't see it in the court's analysis, was the violation. Which one are you hanging your hat on?
Here's the petition.
Is asking for the trustees to be removed questioning the validity of the trust if the action she was seeking was a result of what she thought were,
breach of fiduciary duty.
breaches by the trustees? How would she, if she wants to say, look, trust, fine, trust is valid, good for you, but the way the trustees are managing this is breaching their fiduciary duty, Are you saying she could never make that claim in court without violating the interim clause? Just the administration of the trust? She's not saying the trust is wrong. She's saying the way it's being handled is wrong. That's the administration of the trust, isn't it? I think that's kind of what we're getting to, is we see a lot of these claims as claims that are going about the administration of things. Documents she's getting, breaches of fiduciary duty, but what we're asking you, I think, back to Judge Catani's original question, what claim of hers actually goes to saying, this will is invalid? This trust is invalid. I am talking about the validity, the very nature of the way these were set up. That's what the forfeiture clause said you can't do. And so we're asking, of all the 26 claims that you say merit or not merit, which of those go to the validity of either the will or the validity of the trust?
The obvious ones relate to the First and Second Amendments, in which she's coming in to say Hal didn't have capacity, not even in 2015.
She won on the second one, right?
What's that?
She won on the second one.
No, absolutely not.
The court didn't count that as an enforceable document.
There's a big difference between probable cause and winning, and she absolutely did not win. If you read what the judge said, the Second Amendment, what you all have to do, the Second Amendment, when you look at the evidence was, and you have to take the evidence in the light most favorable
To affirming.
to the trust.
Well, to affirming at this point.
Because you didn't cross-appeal that. So we have to say they made findings, you didn't appeal those findings about the Second Amendment, and that judge said that wasn't a controlling document. Well, you're laughing, but I don't think we understand what we're missing, because you think that's funny, but we're saying, where is it? I mean, how do we not say that those rulings that the judge made as not considering the Second Amendment as a controlling document isn't a determination that there was something underlying wrong with that?
Okay, if you have a careful reading of the judge's ruling and you combine it with his judgment, in his ruling, he's saying, I find the Second Amendment troubling. He does not say that he's overruling it anywhere. And therefore, you can't assume that he did.
But does he enforce it in any
He didn't
way?
enforce it.
He didn't find it controlling. Exactly.
He found that the controlling one, under the interim clause, would have a certain result. And if he used the Second Amendment, he would get the same result. And so you have a double whammy in which she cannot possibly get the remedy that she sought, and she's going to seek it anyway.
So you're saying there's absolutely no PC, no reasonable belief that could support her claim, challenge the Second Amendment? Because that's what you have to have the interim clause apply. No probable cause. Let's set aside whether it's still enforceable, because it was done at the end of father's life, drafted by one person who was the only person having contact. It was obviously kept secret for a while, kept secret at least from Nancy. And all the other things that go with it. That's the kind of thing that establishes some sort of reasonable basis to get an evidentiary hearing normally. How is it not?
The evidence that you're putting forward has to be true. When you put in a petition, you base that. You usually put in an affidavit. You can have some emotional summary judgment.
Did the son draft it?
What's that?
Are you saying the son didn't draft it? Are you saying Dad wasn't about a month before his death? Are you saying it wasn't disclosed? I'm not sure what you're saying isn't true.
Here's the issue that I'm trying to answer you with. The issue is, if you have one basis for bringing some claim, is that enough to cover every claim, and you just don't have to worry about the interim clause anymore? That's not.
Well, let's set aside, let's do one thing. Let's agree, just for purposes of argument, I know you may not agree, that all of the changes to the administration don't matter. There were two things she challenged, and you tell me if there was something more. She challenged the enforcement of the First Amendment. She challenged the enforcement of the Second. Did she challenge any other document? She didn't challenge the will, did she?
I don't know.
All right. Let's assume that those were the only two. So she needs probable cause for the Second, and I've just talked about what we were talking about. She didn't just have probable cause, but she actually prevailed on part of the First Amendment because the provisions regarding the decedent's trust were invalid. So how is it that those two claims trigger the interim?
If she makes some claim for which there is not probable cause, which she did, as to the First Amendment, as to the will, she's trying to get rid of that stuff. She's not going to follow the interim clause. She's not even listening to the interim clause. So she has these claims, and she's got the two that you're talking about and the additional one.
Which one didn't she have probable cause for? One or two?
One.
So she didn't have probable cause even though she won, that the changes to the decedent's trust were invalid. How did she not have probable cause to support that? She won.
If she makes a claim in that petition which is not based in probable cause,
You're saying in addition to these two?
Yeah, if she makes,
You're counting, but then you're saying, so she sues a lawyer. That somehow violates the interim
I'm
clause?
not talking about suing a lawyer.
You put that in your brief. You included that with 25 claims. Which other ones are relevant to the interim clause? A bunch of other claims. So she's complaining about lawyers, saying they're aiding a fiduciary duty, a breach of fiduciary duty or something, making claims that on their face seem plausible. Why do they violate, even if they're not plausible? If they're not challenging the will or the trust document, why does it implicate the interim clause?
If you're going into a First and Second Amendment challenge and you have some basis, you better make sure that every claim
Why
that
does
you
it matter?
make
Why
under
does it matter?
Sheehan, under the case law of the court, you have to have a basis for every claim, and she did not.
But only every claim covered by the interim, which is to challenge the enforceability of one of the documents, not the administration.
I don't necessarily agree.
I understand. I'm saying, all right.
That you can ignore the.
So let me ask you this. The folks who were administering the trust, the trustees, denied her claim. You're saying that under the interim, her challenge to a wrongful denial by itself disqualifies her?
Not at all. It's all the other stuff. The stuff that she was doing, which was just wrong.
But let's
try and make
So isn't that a basis for asking for attorney's fees but not interim? Because that's what it seems to me you're arguing. She should have to pay attorney's fees because she drove up the cost of litigation, but that's not the same as disqualifying under the will.
You're right about that. There's a very good reason for the bad faith claims, and we haven't talked much about that.
But I just want to pin you down on let's say she files a complaint for defamation against one of the trustees as part of her lawsuits. She said, you've said untrue things about me. Does that implicate the interim clause? This is strictly a hypothetical. She files, as part of this, she's filed, I was entitled to an accounting, you didn't give me one, and also you defamed me by saying that I've done something that I haven't done. That implicates the interim clause?
No, simple answer no, but you're talking about the entire case and all of the stuff that she did and all the claims that she made, and you're trying to say there was what I'm suggesting to your honors is that there were claims that she made that she didn't have a basis for, trying to contest the validity.
But she didn't have a basis for alleging defamation. She didn't have a basis for it, but she alleged it. Does that mean she's disinherited?
Not in the scenario you're giving, no, but all the other.
Sir, we've asked a lot of questions, so if you want to give a 45-second wrap-up, please do.
The concern of the co-trustees is to look at what was done to this estate and why it was done. And that, I think, was the concern for the trial judge. How on earth could we have a system which doesn't do what they're asking, the testators are asking for? That's the overriding concern. Why don't we follow what the testators want? And Nancy was making claims as to the validity that go beyond the two arguments that Judge Goss has made. Or not, he's not making arguments, but they go beyond that. If you look at the claims that were made, they do go to the validity. She made claims that were not justified under the case law.
Okay, thank you so much.
Your Honors, I guess I would start my rebuttal time with asking if there are questions, because I believe the court has identified the very heart of this nature, which is, or this issue, which is that Nancy may have made lots of claims. They did not challenge the validity of the trust. She made 2 claims to the challenge to the First Amendment, challenge to the Second Amendment. From our perspective, she won both of those things. In the First Amendment, she was successful because the trial court indicated that they couldn't mess with Mary or Mother's trust. The Second Amendment, they didn't enforce. Counsel is upset in that we can't have a system that doesn't allow for punishing Nancy for all these 26 claims. There is a system. They didn't use it. The system would be that they ask the court to dismiss her claims and seek fees. They could have a vexatious litigant allegation to stop her from making these additional filings. In this case, however, Your Honor, every filing she made with the assistance of counsel. And the assistance of counsel gives it some level of credibility in terms of whether or not she believed, she had probable cause to believe, that she was going to be successful.
Very quickly, counsel, because the one argument he makes, which has some visceral appeal, which is the father did seem to want to limit Nancy's inheritance. Father seemed to want to limit Nancy's inheritance. And that didn't happen here. Can you just address, I mean, that is usually our goal, but why, because given the plain language, shouldn't that end up carrying the day?
Father did not want to limit Nancy's inheritance. If you believe that the Second Amendment was not enforceable, as the trial court determined it would not be a controlling document, the First Amendment said specifically that she was to get a $50,000 loan, a jewelry, and then everything else was to be transferred into Mary, Mother's trust, and she was to get her 1/3.
But does that subtract, sorry, I know we're going over time, but are you suggesting that Mary could get something outside, and then does she still get 1/3 of what's left? Does she end up overall with more than 1/3 of the combined estates?
If you read if you follow the document terms, she would end up with a $50,000 reduction, loan forgiveness, and then the jewelry. And according to the First Amendment, that was to be used to assure a 1/3 equal distribution. So what it actually says.
So you're not claiming that she should get 1/3 of everything else? That is an offset from the overall amount of the estate?
Correct, Your Honor. And it's found in the First Amendment specifically. I know we're over time.
Right.
But
It was an offset. Okay,
Right.
thank you.
Thank you. Your Honor.
We will take this under advisement and just issue our decision in due course, and we are at recess. No, we're done.
Recess.
Recess,
we
we're
adjourn.
good. We adjourn.
You're adjourned. Not as